Welcome to this latest edition in our video interview series here at iConnect. My name is Richard Albert, and today I'm joined by Haider Hamoudi, Associate Professor of Law and Associate Dean for Research and Faculty Development at the University of Pittsburgh Law School. And today our discussion will be on the Iraqi Constitution. I should note, however, before we begin, that I am dialing in from the University of Ottawa, the nation's capital in Canada, where I'm a visiting scholar for the month. I'm really grateful to my faculty host, Vanessa McDonnell, for having me here to collaborate, to exchange ideas. It's been a wonderful few days so far, and I'm looking forward to the rest of July. The University of Ottawa, I've known for a long time, and I'm finding out even more still, is a great place to do comparative public law. So I'm very grateful to Ottawa for having me here. Now, Haider Hamoudi is an expert on the Iraqi Constitution. He's written a book, 2013 book, on negotiating in civil conflict, imperfect bargaining, and constitutional construction in Iraq. Moreover, Haider was, in 2003 and 2004, a legal advisor to the Finance Committee of the Iraq Governing Council. And that's not all. In 2009, Haider advised the Constitutional Review Committee of the Iraqi legislature. So Haider has been deeply interconnected and involved with constitutional developments in Iraq. And so we're really grateful, Haider, for your time today as we try to learn more about the Iraqi Constitution. So thank you for your time.
Thank you, Richard. I'm very grateful to have the opportunity to speak to you about this.
So Haider, let's begin. In your book, Negotiating in Civil Conflict, Imperfect Bargaining and Constitutional Construction in Iraq. In this book, you describe Iraq's constitution as imperfect and even incomplete. But you do say that it's the best that could be done under the circumstances. Why is that?
Well, Iraq was divided in a way that I would describe as unusual, although by no means unique, among three disparate communities, the Kurds, the Shia, and the Sunnis. And these divisions weren't purely over power sharing alone, but they were also went to the heart of what the state should look like. So the Kurds were committed to a relatively secular state, but were particularly committed to a confederal sort of association with maximum autonomy given to the regions, and Baghdad left as weak as possible. The Sunnis were committed to a Baghdad-centric, very French model sort of a society in which all the major decisions are made in the middle. Arab nationalism, in fact, was dominated. All the Arab nationalist parties that dominated Iraqi politics prior to 2003 were all Sunni dominated. So Arab nationalism ran strong. The Shia had some level of Arab nationalism, but really were more committed to this idea of the Islamic State, and an Islamic State where Islam was largely articulated by the Shia jurists of Najaf. And so you had three very different ideas of what the state should be and what it should look like. These ideas had developed over the course of decades, and the idea that everybody was going to be able to get together and agree on everything in a room just was unlikely. In particular, or adding, I suppose, to this complication is the fact that the way in which the regime change took place was so, that rupture was so fundamentally, let's just say, external, exogenous, so that no party, as opposed to say what happened in the 1990s and the late 1980s in Eastern Europe, no party sort of came to realize their time was up. And it was time to negotiate sort of an exit, effectively. You just had three different groups who were going to contest for political power who had massively different ideas. And so what resulted was a constitution that was imperfect and incomplete in the sense that you couldn't resolve these core questions in the text itself. And so you left them for later resolution.
So an incomplete constitution suggests that there is work still left to be done. Constitution making is difficult and tricky business. So how would constitutional drafters leave or defer difficult decisions for later resolution?
Well, there's a variety of ways. Perhaps the most obvious and the one that I imagine would be most natural to almost anyone would be the drafting of text that's somewhat ambiguous or vague, which later constitutional actors, whether they be courts or administrative agencies or legislatures, could then fill in to sort of mean what they think it does. Another common way to do things would be to defer things for future legislation. India is famous for this with respect to its personal law. It says, well, we're going to have a unified personal law, but we don't have it right now for the Muslim population, and we will do it in the future. A third way is through contradictory text. I don't mean that one provision completely contradicts the other, but in Iraq you had this, the Irish Constitution 1923 has this as well, but you have these sort of provisions that seem not to fit particularly well against each other. So in Iraq, for example, the provinces will enjoy a great deal of autonomy that's fiscal and administrative, and this will be organized by a national law. That's one provision. Another provision, any conflict between national law and provincial law, the provincial law trumps the national law. Well, these don't fit particularly well. I mean, there's not a direct conflict, but how can the national law both give you the power, and then once you have the power, somehow you can overturn the national law? So, so one can see the contradiction. And let me just say a final way is through aspirational constitutionalism, to say, the state will guarantee housing and will take progressive measures to ensure that. There's an expectation of something that is going to be done. There's an understanding that it can't be done tomorrow, and that leaves constitution makers later constitutional actors with a fair level of discretion in deciding how they're going to move these things forward. And all four were actually done in Iraq at different times.
All four were done in Iraq. So could you give us some examples, Haider, of deferrals of these difficult decisions that have worked out?
Yeah, sure. I'll give you two. The federalism one is probably a good one to start with. As I said, you had an article that seemed to grant national law some level of precedence because it would determine the extent to which provinces would enjoy autonomy. And you had a separate law that said provincial law, to the extent that it conflicts with national law, the provincial law controls. The provinces, importantly, were those areas that were to enjoy some sort of semi-autonomy, which was different from a separate group of called the regions. Really, there's only one right now in Iraq, the Kurdistan administrative region, where a great deal more autonomy is contemplated. And what we found was, as the constitutional actors began to develop, as courts began to interpret things, as the legislature itself began to write legislation, the understanding became, well, the provinces don't really need that much autonomy. And we started to move in a more centralized direction. I don't mean pure French model, but something that sort of was much more placating to the Sunni groups, at least at the time that these things were happening, and ways in which, let's just say, the article of the Constitution that really emphasized that the national government would determine the extent of the provincial autonomy took precedence over the regional one. And for some period of time that worked. Later on, ironically, parties switched sides, and the Sunnis decided they wanted a little more autonomy, and things got a little more complicated. But at least it sort of brought things together for some period of time. Islam and the state is another one. What's very interesting about Islam and the state, and I'll focus on the family law just to give you a brief example. You had this family law that was, Islamic in origin, but had a number of important reforms in it. And Islamists wanted to repeal this whole thing and say, well, everybody goes back to the juristic rules of their own sect and their own religion, and that's what we'll do. But they watered that down into sect and religion and opinion and conscience and whatever. And it'll be organized by law. And the way the court interpreted this was to say, well, look, I mean, we don't know when you start to say sect and religion and opinion and everything, we can't just repeal a law and say, everybody just do whatever you want. I mean, you can't organize family law that way. So what we'll do is we'll defer to the legislature, and the legislature at some point is going to have to create a law, right? We'll declare this non-justiciable effectively. And the legislature will have to declare a law determining the extent of autonomy for each individual group to follow their own sect and religion and whatnot. And that actually has worked reasonably well, by which I mean you continue to have a unified family law, and you will have Islamic groups say we've got to change it and make it more Islamic, and you'll have secular groups saying we should reform it to make it more secular. But that contestation largely takes place in the legislature. So for all of Iraq's problems, and it's got significant ones, obviously, problem of the role of Islam in the state, at least within those parts that continue to be under the control of the federal government, there's not really that level of violence that exists in a lot of other post-Arab Spring states, whether it be Egypt or Syria, on that particular question.
So just a reminder, we're here with Haider Hamoudi, Associate Professor of Law, Associate Dean for Faculty Research and Development at the University of Pittsburgh Law School, and we're talking about the Iraqi Constitution. Haider is one of the world's leading experts on the Constitution, having served as an advisor to the Constitutional Review Committee, having served as an advisor to the Finance Committee of the Iraq Governing Council, and of course having authored a leading book on the subject, Negotiating in Civil Conflict, Imperfect Bargaining and Constitutional Construction in Iraq. And I've just asked Haider for examples where deferrals of difficult decisions have actually worked out, deferrals of subjects in the constitutional design itself, where that has actually worked out. And so now, Haider, what about deferrals where we're not quite sure that things have worked out the way we would have liked them to?
Yeah, and I think the best example of that is probably with respect to the idea of power sharing. You have this, you have three disparate communities. You have a majority Shia population and then two minority populations, which combined are, I'm going to say 45%. There is no competent census, so everybody will change the numbers as they wish. But let's say 55 to 45, with the 45 divided equally among Sunni Arabs and Kurds. And so the issue that always arises in these kinds of things is, well, how do you divide power? And what has been particularly ironic was that the Shia juristic academies, as flexible as they were on Islam and the state, allowing that kind of watering down that we just talked about, were very inflexible about the much more modern idea, less about Islam and the state and much more about the modern idea of majoritarianism, where the majority, one man, one vote, one person, one vote, excuse me, everybody let's go out and vote, and then whatever the majority decides is basically the case, and the minority will have people in parliament yell and scream, and that's their right, but ultimately there's this sort of untrammeled majoritarianism. It became very difficult to develop these power sharing arrangements. The Constitution tried to develop one, and it wasn't a particularly good one, and it didn't work. It was the idea that there would be two houses, so you'd have a sort of a majoritarian lower house, and then an upper house that would be equivalent to the House of Lords, but rather than lords, you would have regions and minorities with perhaps a larger say. And like the House of Lords, the legislation would go up and could come back down. The problem that ultimately emerged was that they couldn't agree on the formula for creating that second house. In other words, how much minority voice would be there. So what they did was they created this thing called a presidency council, and they said, well, until we get that thing set up, we'll have one Shiite, one Sunni, one Kurd. It doesn't say that in the Constitution, but it says three people, but that's what they mean. And those three people will together have a veto power. Any one of them vetoes a piece of legislation, it's like an upper house of parliament. It got to go back. It can get overruled by I think 60% vote, but that's going to be hard to get. And that actually worked. The problem that really developed was that rather than sort of the Constitution designing this so that it continued indefinitely, you had a presidency council that sort of continued. It only existed for one term, the assumption being after the one term of presidency, we'll have the other one set up and we'll be fine. That was very short-sighted, frankly, of the constitutional drafters to think that they could resolve that problem of power sharing, which continues to bedevil Iraqi politics. And it failed miserably, I think, and it is a large reason for the Sunni disenchantment, because the Sunnis don't feel like they really have a voice in the state. That is to say, they can constantly be outvoted. They don't really have a veto power. And so that notion of power sharing and how to bring in everyone so that they're all participating in decisions of the state is one that continues to be a problem for Iraqi politics. And I think had a better mechanism been designed, I couldn't say these problems could be avoided, but we at least had a chance.
Yeah. One thing that I've always found interesting about the Presidency Council, Haider, is that it seems to have been an effort to use constitutional structure to help shape political culture. And it doesn't seem to have worked, as you say.
Yeah, no, I think that's right. I mean, I think there's a couple of reasons why I think it didn't work terribly well. One, as I said, is that it sort of disappeared. But the other is that in order to shape that political culture more effectively, and I like the way you just phrased that, it's easier to do this through some sort of upper house or through continually elected representatives. Because when you have a presidency council, you're effectively forced into one person acting as the voice of each respective community. And that's fine when you think of it as sort of a symbolic thing, kind of like, the Israeli president, or, the Indian president, the guy who shows up with the ribbons. So we'll have all three show up because, everybody wants to have their person there. It's not fine, I think, when you're really talking about power sharing. I think to shape that political culture more effectively, an upper house or some sort of other deliberative body where you have more continually elected figures, one of whom can replace the other, gives populations more of a sense that they really have a voice in that body.
So as to Iraq, Haider, you've given us example that counsel real pause when deferring decisions, difficult decisions, constitutional design. But you've also given us examples that suggest some optimism, cautious optimism about the use of this device in constitutional design. But here's a question, maybe a larger theoretical question. Why shouldn't constitutional designers just sit together in a room and take the necessary time to hammer out the necessary bargain, to finalize the deal, rather than to defer a decision that, as you say, could be very difficult, could be very charged, controversial, for later eruption?
Well, I think that they probably should, to the extent that it's possible, try to work on and solve as many of these problems as possible. I think it would be a mistake to defer everything. And I think the criticism of the Iraq Constitution that it probably defers too much is probably accurate. At the same time, I do think that there are certain things, such as the role of Islam in the state, where the divisions are so deep and so raw that one is unlikely to be able to get a final resolution at a constitutional table. In fact, if everybody's doing what Jan Elster suggests at the constitutional table and thinking in the long term, that makes the problem somewhat worse, because I can't compromise at all now. Because if I compromise, then I've compromised for the next 70 years. If I can defer this, if I can say, well, what we're going to do is solve this piecemeal. So here's our view of what the Constitution should say. Here's your view. We'll draft something ambiguous, maybe in between, and then piece by piece we'll work it out. Much like, say, the Spanish Constitution on federalism, right? I mean, they fought a civil war about this in the 1930s, and there's still a fight about this. How much autonomy should communities have? Well, we can't resolve this. So you get the sense of, if we can turn this away from a generational solution and into the more political log rolling that one expects. We'll do this here, we'll do that there. Each one is going to be a piece. We might have an opportunity to create what's called what Hannah Lerner calls incremental constitutionalism. That is to say, by increments, we'll get to some sort of workable political solution. I don't consider it ideal. I think the model that you're describing, sort of the classical model, is preferred if it can be done. But I do think that there are times in which it's just not possible.
Yeah. So it doesn't seem, Haider, like the Constitution is the problem in Iraq. There's some good, there's some bad. So what has gone wrong since this document was ratified about 5-6 years ago?
Well, I think the main thing that has really gone wrong in Iraq since the Constitution was ratified is that the method of deferral doesn't really solve a problem. What it does is help push off the problem. And as I said, that's not ideal, but sometimes it's sort of one's forced into doing that. But when you push off the problem, you then have to tackle it later, at least slowly and in incremental fashions. And while the United States was present in Iraq, you got the sense that there were motions in that direction. And that's largely, the book sort of ends at the end of the U.S. presence. Not that, that's just by timing. Of when it came out. And you had steps that would be taken on all sides and sort of groups starting to come together and feel each other out. What happened was sort of a rush towards an increased level of sectarianism, in particular between Sunni and Shia. Although Arab-Kurd didn't go better, but it didn't go quite as badly. Sunnis felt increasingly disenfranchised from the state, and one could blame anybody you want to. Most people tend to blame the Shia as the majority community for not doing more to include them, which is fair. You also have, extremism that seemed to pop up in reaction among the Sunni side, and a failure to sort of come to terms with a minority status in a state which they had long controlled. So there's arguments on all sides. But what you did have was a drop of dialogue. and an increasingly polarized and sectarian state. And certainly the Prime Minister, Nouri al-Maliki, didn't help matters by exacerbating matters further by using highly charged rhetoric that alienated the Sunni community further. So this deferral process, pushed the problem off, and what the hope is that people come together and draft legislative solutions and move themselves together. And they did for a few years, but then everybody started to drift apart again. And that, I think, is what really created the crisis in Iraq today. Less the Constitution and more what's happened since then.
And so what's your prognosis, Haider, for the country?
That's a good question, and it's difficult to know exactly where things will end up. I think that we're probably going to end up in ironically, what the original drafters envisioned, which was a largely federalized and decentralized state. That won't happen right away. It can't happen right away because of ISIS. But I think if one assumes that ISIS will be defeated eventually, as I assume it will, as all these sort of extreme radical groups tend to be, what you're going to end up with is three populations that really have grown not to trust each other, that the divisions that have built up and the conflicts that have built up have been so great that one could, within the Iraq Constitution, there's plenty of resources to manage a largely confederal state. As I said, it's capacious enough, and its language is capacious enough to grant Sunnis the same level of autonomy that the Kurds have. And my guess is that we're probably moving in a world in which we'll have three separate autonomous communities. Before we get there, I think the world would have to be convinced that a Sunni autonomous region could exist that wouldn't be completely controlled by Islamist extremist groups, and that'll take some time. But my guess is when the conflict settles down, that may be where we end up.
So we've been spending some time with Haider Hamoudi, an associate professor of law and associate dean at the University of Pittsburgh Law School, talking about the Iraqi Constitution. Haider is an expert on the subject, but not only an expert in the public law of Iraq, but also of the private law of Iraq. Haider, I've seen that you've posted a paper on SSRN recently on family law in Iraq. Could you tell us a bit about the paper?
Sure. It refers back to something I was talking about in the constitutional, and it's sort of what got me interested in it, the constitutional debate over the role of family law. And what the Constitution envisions is the opportunity for different religious communities, as well as other opinion communities, if you will, to draft their own family law and sort of put it out there and then be governed by that. And so there have been different minority communities, Christian communities alike, who produced drafts, none of which have come into law, but have been less controversial. The most controversial by far is the one that I've been writing about, which is the Shia one. And it really does turn back the clock in some important ways to try to replicate some juristic rules, although, and this is the theme of the paper, it only does it piecemeal. It largely ignores juristic rules it finds inconvenient. It sort of demonstrates the way in which, and that's the title of the piece, the political codification of Islamic law. Islamic law is sort of a political, an area of political consultation as much as anything else. It's not some pure juristic thing, or if it is, when it finally makes itself into the legal arena, it moves into a political object that is manipulated, changed, altered in order to produce a result that is politically appealing, but in terms of some sort of pure interpretation of sacred text, is it would be almost preposterous to suggest that's what's come out of it. The laws never sort of come into effect, but it sort of demonstrates some of the ways in which the role of Islam starts to take on these sort of highly politicized dimensions in countries like Iraq, where a greater role for Islam in the legal infrastructure is being contemplated.
That sounds fascinating. When I publish this interview, Haider, on iConnect, I'll include a link to your paper on SSRN for readers to download.
I appreciate that. Thank you.
Well, Haider, thank you so much for your time. This has been really fascinating to me, learning about the Iraqi Constitution, its promise, perhaps pitfalls. Very, very fascinating. And let me also acknowledge once again the University of Ottawa for hosting me here. I'm actually calling you, speaking with you, Haider, from the office of Jenna McGill, who's an assistant professor here, who's been so kind to let me use her office during my stay. But Haider, once again, thank you for your time today. We'll post a link of your paper. We'll, of course, post a link of your book, which I commend to all of our viewers.
Mm-hmm.
And it's been a pleasure. Thank you.
Thank you, Richard. I really appreciate the opportunity to speak with you about this all-important subject.
Okay, bye-bye.
Okay, take care.